Well, good morning, everyone. Thanks for braving the really bad weather. We're so glad that you could join us this morning, and this is the first public program that the Asia Society Policy Institute is holding this year, so we welcome you. Before I talk about the program today, I wanted to highlight an upcoming event we'll be holding at the end of March that will feature the Indian ambassador, Gil, along with a panel of distinguished experts. And the topic of that event will be artificial intelligence and other new technologies and the changing security environment in Asia. And in particular, we'll look at how the US and its allies can work together to ensure that these technologies are leveraged to promote peace and prosperity. This morning, our discussion is especially timely. Could we turn off the phones? Okay, well, can you answer it? This morning, our discussion is especially timely given the mounting criticism facing the WTO dispute settlement mechanism. Needless to say, this system is facing unprecedented challenges and is seen by many as failing to keep up with them. Some believe that the dispute settlement system is in crisis. Others believe it's broken and in need of a serious fix. And while others understand that it has deficiencies, they think overall it has served the WTO members well by providing a mechanism to settle trade disputes without political escalation. Furthermore, many recognize that the dispute settlement system has also become a lightning rod for broader criticism about the WTO itself, its relevance, and its effectiveness. You'll often hear WTO officials describe the mandate or structure of the organization as comprised of three pillars: 1, negotiation; 2, dispute settlement; and 3, implementation or the committee work. It's fair to say that the negotiating function is facing its own challenges, and some may call it paralyzed. And now with the dispute settlement system experiencing serious challenges, it's possible that the committee work may become the focal point for WTO activity. And while this work is important, it would be unfortunate. This morning, we're going to focus on gaining a better understanding of what's really gone wrong with the dispute settlement system and how its deficiencies can be addressed, both systemically and procedurally. And to address these questions, we really couldn't have a better group of experts with years of experience working on these issues, both in Geneva, in Asia, in the United States, and in the public and private sectors. So before our panel joins us, we're really honored to have as our keynote speaker, John Adenk, who is the director of the WTO's Legal Affairs Division and just flew in from Geneva yesterday. In this capacity, he oversees the dispute settlement function in Geneva and provides legal advice to the WTO Secretariat and the Dispute Settlement Body. This follows an illustrious career he's had with the New Zealand Ministry of Foreign Affairs and Trade, including New Zealand's ambassador to the WTO. The way the program will proceed is John will provide about 15 minutes of comments, then we'll open it up to Q's and A's, and then the panel will join us for a moderated discussion, and then we'll open up to the audience again for questions and answers. So without further ado, please join me in welcoming John.
Well, thank you, Wendy, for that introduction, and thanks to the Asia Society for the opportunity to speak to you here today. And just to note that I'll be doing so in my personal capacity, not on behalf of the WTO Secretariat or WTO members. Now, I should also mention that when I agreed to speak, I wasn't aware of the precise title that Wendy would give for today's event. So forgive me if my comments today are more directed at highlighting some of the challenges that the WTO dispute settlement system is currently undergoing and where these may lead, rather than agreeing that it is, as of now, broken. Now, with that disclaimer, let me begin with a bit of historical context, which I think is important to recall as we reflect on the current state of play. Now, when I began my own career at the WTO as a delegate, In the very first years after the entry into force of the WTO agreement, it was an exciting time. Members were still celebrating the huge achievement of the conclusion of the Uruguay round, which not only consolidated the acquis of GATT rules that had evolved since 1947, but had also complemented those rules with entirely new agreements on services, agriculture, and intellectual property, as well as updating and multilateralizing a number of earlier GATT plurilateral codes. Now, while there may be a tendency today to take these Uruguay round rules largely for granted, I think it's widely accepted that having those new WTO rules in place, including an effective dispute settlement system, has proved to be an important and essential insurance policy, particularly at the time of the global financial crisis. From today's perspective, when securing multilateral agreements seems to be ever more elusive, many often wonder at how that grand bargain achieved at the end of the Uruguay round was possible. And to me, the success of the Uruguay round is best summed up by two words: self-interest on the part of the main protagonists in the negotiations, and particularly the EU and the US. In regard to dispute settlement, the decision taken to move to a more automatic and compulsory dispute settlement system than that applied under the GATT was a very conscious one. It was all about prohibiting unilateral trade actions and ensuring that there was a way to hold trade partners to account in the full knowledge that the price for this was that you yourself would be similarly exposed to challenges related to non-compliance. And looking back over the history of the GATT in its later years, you can see why things evolved that way. The original system of dispute settlement under the GATT had been extremely informal, even if it became more formalized through the evolution of a panel process in later years. But a defendant could block a complainant's GATT panel request or the adoption of final reports. And there were some prominent examples of this that some people here will remember during the Uruguay round. For example, the European communities blocked the US's panel request in 1987 regarding the EC's Animal Hormones Directive, and the US in turn blocked the EC's panel request regarding the US's unilateral retaliation in response to the Hormones Directive. The European communities blocked the adoption of panel reports in the lengthy GATT bananas disputes. So the current WTO dispute settlement system was very much a considered reaction to this blockage experience from the GATT. And in particular, the WTO dispute settlement body, the WTO committee which oversees dispute settlement activity, now not only automatically establishes panels to examine complaints, but also automatically adopts the findings of panels and the appellate body unless WTO members agree unanimously not to do so through reverse consensus. Now, in addition, members could now appeal rulings to this new institution, the WTO Appellate Body. The rationale behind this right of appeal was that it would act as an additional safeguard against panel reports that were legally defective in some way. And this consideration was seen as particularly important given that under the new rules, panels would be automatically established and their reports adopted unless members by consensus determined otherwise. The new system also provided a way to seek redress in the event of non-compliance by providing for the DSB to authorise suspension of concessions or retaliation. And finally, the dispute settlement understanding contains detailed provisions on compliance and surveillance unique in public international law. When compared to a range of other international adjudicative bodies, the WTO system stands out for a range of reasons. In particular, it is extremely actively used by WTO members. As of today, 538 disputes have been brought for member-to-member resolution at the WTO. Over 100 members, developed and developing, have been involved in these disputes as complainants, respondents, or third parties, and the United States has been the most active, initiating 115 disputes and serving as respondent in 134 cases, with the European Union a close second, having commenced 97 cases and responding in 84 as of winter 2017. This is the Asia Society, and it's also important to recognise that it's particularly significant for Asia-Pacific states. To date, 29 WTO members who are members of APEC and the Asia Developing Member Groupings have participated in WTO disputes as complainant, respondent, or third party. Now, while those members are only 18% of the 164 WTO membership, they have initiated 64% of all the disputes. And notably, the WTO has been used for dispute settlement, even though there's an extensive array of free trade agreements with dispute settlement provisions that could have been chosen, but the members didn't choose to use them. Importantly, the system enables the largest members, the US and China, to challenge each other through dispute settlement, and the US has challenged Chinese policies in 10 cases to date, whereas China has challenged the US in 8. The issue of WTO member control and influence over the way the system works remains a key priority of past and present US administrations. But I think it's important, but particularly as we consider the current situation, to recognise that the existing WTO system already incorporates important elements of member control. For example, members of the Appellate Body, all members of the Appellate Body are appointed by consensus of all members, unlike the International Court of Justice or the Tribunal for Law of the Sea, where the appointment takes place through voting. Consensus provides WTO members, but particularly the most influential members who are more likely to use the leverage that comes with consensus, with a much greater opportunity to seek to ensure that the members of the Appellate Body reflect certain qualities they value, than is the case with those other international courts and tribunals where appointments can be imposed over the objections of selected members, as I say, through voting. The WTO dispute settlement system, far from being broken, remains extremely active at the current time. This includes the Appellate Body, which the Director General recently confirmed is still very much working. And we have seen dispute settlement activity intensify further in recent years, as illustrated in some of the material that's been circulated for this event. Now, there may be different perspectives on whether this is a good or a bad thing, depending on whether you're a complainant or respondent, but I think it shows that members, and particularly the major users of the system, including the US, continue to see the WTO as a viable option for pursuing legal redress. And finally, members comply with rulings in nearly 90% of cases. So while all of this has been recognised as a considerable achievement, none of this is to suggest that the WTO's dispute settlement system is perfect. It clearly isn't. And since its inception, members have had a range of discussions talking about improvements, none of which have come to any sort of final consensus around amendments to the dispute settlement understanding. There have been a number of challenges that have emerged over the 23 years that the system has been in place, and I'll just run through a few. First, I think it's fair to say that we now see a number of disputes that involve much more complex or complicated issues than was the case perhaps in the early days of the system. Submissions, exhibits can be voluminous in nature, and this clearly has an impact on actually the detail that has to be addressed in the reports of the panels and in the time frame for concluding those reports. Secondly, more panel reports are appealed and more claims of non-compliance have been filed, requiring panels to examine whether members have implemented the recommendations and rulings of panels in the Appellate Body. Again, those compliance panels can be appealed, which prolongs the time frame to bring a dispute to a close. And third, in various areas, the DSU procedural rules are not crystal clear in the view of some members, and this creates a number of complications in individual disputes. Now, more generally, throughout its history, the results generated by dispute settlement panels and the Appellate Body have in some cases attracted criticism from members, and this is not surprising. It's not uncommon, I think, in international litigation for decisions that are not seen as favouring a party to engender vocal criticism from that party. And we see that phenomenon in all dispute settlement systems, I think, whether they're domestic or they're international. I'm sure we will hear more in the panel discussion today about some of the specific criticisms that US stakeholders have made about wrong decisions and overreach by panels or the appellate body. And the strength of concerns that have been raised here is acknowledged. But I think it's also important to recognise that other members have in the past voiced their own concerns about supposed appellate body sort of overreach in cases where the appellate body was supporting positions advocated by the United States. For example, recall the appellate body's decision back in 2000 that if it wished to, it could accept amicus briefs. The decision was very controversial, with a number of other members who argued that the appellate body was, in effect, making new law by allowing NGOs to submit submissions when they saw it as very much a sole member-focused organisation. The US at that time stated in the DSB that the appellate body was acting appropriately within its rules. So perceptions of wrongness of approach, overreach or underreach, range widely across members depending on the issues, and one member's perception will invariably be contested by others. Now, the DSU, for its part, incorporates a specific warning against overreach by adjudicating bodies. It says in Article 3.2, the members recognise that the dispute settlement system serves to preserve the rights and obligations of members under the covered agreements and to clarify the existing provisions of those agreements in accordance with the customary rules of interpretation of public international law. Now, importantly, it says recommendations and rulings of the DSB cannot add to or diminish the rights and obligations provided in the covered agreements. So that's very clear guidance that both panels and the appellate body have about what they should and they shouldn't do. They should not fill gaps, and to my knowledge, they have never professed themselves to do so, even if members consider that as the consequence of specific rulings. Now, one of the questions that I think we have to ask is, to what extent is it likely to be practically possible for WTO members to further legislate against perceived overreach beyond what is so clearly said in Article 3.2 of the DSU? Recently, I've heard some argue that the real solution to the current situation is for the members themselves to arrive at a consensus that clarifies exactly what these obligations in the agreement sort of mean to avoid overreach. But this will clearly be challenging if the issues to be clarified are likely to be the subject of differing views. I mean, I think that's very clear. So all of this brings us to the more recent events of last year, which have seen the system challenged by the delays and difficulties being faced in commencing a process to fill vacancies on the WTO Appellate Body, a body of 7, which is now down to 4, and could by the end of the year be down to 3. While the US concern about a number of specific appellate body rulings are well known, the more recent concern has focused on the appellate body practice, in accordance with its rules, to allow appellate body members assigned to panels at the time their terms of appointment come to an end to continue on those appeals. This is the so-called Rule 15 issue. In the discussions in the DSB to date, a number of WTO members have indicated their willingness to engage further on concerns around Rule 15 or any other concerns about the dispute settlement system. But at the same time, they've indicated that this should not stand in the way of the commencement of the appellate body selection process, and that any changes to the dispute settlement rules should be on a prospective basis. The chair of the dispute settlement body, Ambassador Ihara of Japan, is continuing to consult with members to see if there is a way through this. Clearly, it's a rather serious problem, but as of now, there appears to be no consensus on a way forward. The consequences of no resolution to this issue will clearly become more serious for the functioning of the WTO DS system as time marches on. In particular, if the appellate body is reduced to the point where it finds it difficult to compose divisions of 3 members to hear appeals, the consequences would be significant. This is because any party to a dispute may appeal panel findings. If a panel ruling is appealed, the panel report cannot be submitted for adoption until the outcome of the appeal has been finalised, at which time the panel report, as amended by the appeal rulings, will be submitted for adoption by the DSB. So if the appellate body was reduced further to the point where it could not convene a 3-member division to hear an appeal, the possibility of securing a timely WTO legal ruling would be undermined. So clearly the stakes are high. The ability of WTO members to hold each other to account for perceived legal wrongs, and this includes the ability of the US, China, and other significant players to have the system deal effectively with their respective complaints that they may bring against each other, would be clearly an issue in those circumstances. So in conclusion, just to note that there's currently much speculation about how members will manage the dispute settlement system in the event the system falters as a result of further attrition of appellate body members. For example, some have suggested members may agree not to appeal panel outcomes so that the report could be adopted, or they could agree to alternative means of dispute settlement such as arbitration under Article 25 of the DSU. Before we get to that point, I would say that the priority must continue to remain to collectively explore, the membership to collectively explore consensus solutions to the current situation. But to do this, it will first need to be made clearer in coming months as to what is actually being sought from the system by those unhappy with its functioning. All of this will require engagement, particularly on the part of the most influential players in the system, to determine if agreement on a way forward can be found. So therein lies the challenge, the outcome of which will determine whether we avoid the break or brokenness foreshadowed in the title of today's event, or whether members will simply be left to deal with the consequences. Thank you very much.
Thanks, John. Those are great comments. The floor is open. Can I ask, when you ask a question, you only ask one question, and you identify yourself, and then I'd like to just take a few questions, and then John will respond, and let's get going. Who has a question? Jake?
Jake Schlesinger with the Wall Street Journal. Thank you for those very interesting remarks. One thing I'd like to hear you elaborate a little bit more on is people say that, you know, a legal system is only good as the laws it's based on, and that there hasn't been any comprehensive update of the rules for quite some time. How does that play into a lot of the issues that you talked about, and in particular, China's the question of China's market economy status and state-owned enterprises?
Okay, well, one thing that I have to make very clear is that I can't actually comment on individual disputes that may be out there for obvious reasons. But I think that one of the arguments that is out there, and you see this reflected in one of the critiques coming forward about the system, is that some consider that disputes are taken with a view to seeking sort of judgments that will deliver effectively rules which hadn't been negotiated by the negotiators. Now, that goes to the issue of whether or not there's overreach in individual cases. It seems to me that when you have a system that actually envisages that there will be disputes, and you will ask adjudicative bodies to clarify the rules in accordance with the rules of interpretation of public international law, that you have to realize that there will be a margin of kind of appreciation as to what those rules mean. It's going to always be a debate as to whether it's basically going further than the rules that have been negotiated or not. But I think that, you know, your question is really, shouldn't members be updating the rule book to provide greater clarity? And I think the problem that you face there is that the relations amongst members at the moment don't seem to be putting them in the space to do that. Yes, yeah, Pablo.
Good morning, everybody. Hi, John. Pablo Bentis with Steptoe & Johnson and formerly with the Appellate Body Secretariat. So, John, assuming we no longer have an appellate body after 2019, how is this going to impact the imperative of security and predictability of the system. During the last few years, you had a number of situations, like in the trilogy of TBT cases, for example, where panels examining the same legal provision came up with different interpretations, and then the appellate body on appeal came up with a single approach to different takes on certain provisions. So are we in a world where we don't have an appellate body? Are we moving into a more fragmented system? And how does that really impact the security and predictability of the system? Thank you.
Well, I mean, I think that's a good question, because I think one of the things you've got to appreciate with the WTO dispute settlement system is that it was a system. It was a system for the first time that obviously involved a sort of a layer of appeal that was meant to iron out some of the legal difficulties that occurred at the panel stage. A number of members don't believe that that's been done successfully in some cases, and I think we note those views. But I think it's fair to say that there are real questions about what that system would represent if, in fact, you don't have a functioning appellate body, and you would have these fallback options, which I've mentioned, which are essentially panel reports that would only get adopted if members agreed to their adoption, disputing members, so you need consent, arbitration under Article 25 of the Dispute Settlement Understanding, which is an option. The other thing that I think is quite interesting here is I mentioned, the number of WTO members who are parties to FTAs who actually don't go to the FTA dispute settlement machinery. Why? Because they think that they can rely on a more robust sort of system in the WTO through the experience it's built up to rule on legal issues that they may put to it. So I think, that in one word, yes, there are, I think, real issues there. Yeah. Yes. Yeah.
Hi, I'm Doug Palmer with Politico, and I've only been following this issue somewhat from afar, so I'm not really abreast of all the details. But your last comment I thought was sort of interesting, where you said it needs to be clearer in the coming months about what is exactly wanted from the members who have complaints. And again, not following it closely, it's my impression it's mainly the U.S. that has an issue. So are you saying that the U.S. has not clarified exactly how they want to reform the system?
No, I think what I'm saying is that in order to reform the system, you need to get consensus on something that would replace something that's there at the moment. So there would need to be some sort of proposal about what you need to do with the system in order to resolve these differences. And in recent times, the US concerns have been, as I say, focused around certain specific rules that the appellate body have in place, the so-called Rule 15 rule. Now, Rule 15 is simply this rule that provides for a transition. Once someone's term finishes, they will continue on the case until the appeal is settled. Now, the US position on that is that that's contrary to the DSU, and the appellate body was sort of ultra vires in adopting that. But I think it's fair to say that a number of members are aware that the US have a number of other concerns that go more broadly than that. And the question that I think a number are asking is, well, what does the US actually want to do with this sort of system? It's a system that the US continues to use very actively itself. It's initiated panels very recently and is taking them through. But I think we will need clarity in that area before these conversations that will have to take place between the major players can actually go very far. And at the moment, I think it's fair to say that we could be in for a bit of a wait, because I don't think something is going to happen next week or maybe next month. But as appellate body members come up for reappointment, the issues will become more in focus, I think.
One more question.
Jack Capral with Inside U.S. Trade. I just wanted to follow up on one point, which is we're waiting on clarity for what the U.S. wants to do. Sorry. It just seems as though the U.S. criticism is clear, and given that the WTO is a member-driven organization, it's always puzzled me why the onus seems to be on the United States to come up with solutions, especially, based on my understanding of the issue, it's the U.S. isn't the only WTO member that has concerns about overreach. Any member can propose solutions to the problem. It is a consensus-driven organization, so more voices and more ideas would be a positive. So why are other members kind of waiting on the sidelines if this is an issue that affects the entire WTO?
I don't think it's a case that other members are waiting on the sidelines. I think there's actually been quite a lot of informal discussions that have gone on about, Rule 15 and what are the possible options sort of with Rule 15. If Rule 15 was to change, the Appellate Body would need to change Rule 15. But there are a number of members, I think, who are saying, look, let's get into a discussion where we can talk about some of these things to see if in fact we can resolve them to the point where we can resolve the current impasse, or are there more fundamental things that it might actually be more difficult to sort of resolve here? And that openness, I think, has been expressed by a number of members. A number of members, of course, will say we completely disagree with any changes whatsoever. So the question that members will face, I guess, is, as they confront the consequences of the ongoing impasse, is this conversation going to deepen and get more sort of direct? At the moment, as I say, I don't get the impression that that things will happen quickly on this front, but they will evolve in the course of the year. Okay. Thank you. Thanks. Thank you.
Join me. And if I can invite the panel up now. Sure. Do they know where they're sitting? Okay. Let's go. All right. Thanks. Well, thanks to John for really setting the stage. I think a lot of the issues that he raised we can go into more detail with this excellent panel we have. I want to briefly introduce my colleagues on stage. You have their bios in front of you, but let me just do this quickly. To my left is from Tokyo, Ambassador Yoichi Otabe, who is Japan's ambassador to the WTO for 5 years. He was previously Deputy Foreign Minister for Trade. Dear friend and colleague, we worked on a lot of issues through the years, and I will say it now, you're a great counterpart, but if I said it in those days, you probably would have been fired. Next, we have Terry Stewart, Managing Partner of Stewart & Stewart, a legend in the trade remedy area, a trade veteran, having been involved in hundreds of trade remedy cases and having helped shape trade policy in both the United States and abroad. To my right, also from Japan, we have Paul Bluestein. Many of you know him as a former Washington Post reporter. Some of you know him from his legend book on the WTO, Misadventures of Most Favored Nations. He is now a senior fellow at the Center for International Governance Innovation, and he's writing a book on China and the WTO, and his latest article called China, Inc. in the WTO Dock, Tales from a System Under Fire is available outside, and he'll talk about that during his remarks. And finally, we have Stephen Coe, who is also a long-term friend and colleague. He brings incredible, interesting perspective here, having served both at USTR, pursuing WTO dispute settlement cases, and now with Aiken Gump, representing clients who are pursuing WTO cases. So that's the group, and I'm going to start with some questions, and then after a while, we'll open it up to the audience. So Yoichi, you have served in Geneva for 5 years, and what I wanted to ask you was, can you comment a bit about the 3 pillars of the WTO? So we have the negotiating pillar, the dispute settlement pillar, and I guess what do we call the committee pillar here, or the implementation pillar? And in your view, it'd be interesting, based on, with your perspective, how are these pillars working and how are they not working, and how are they interrelated?
Okay, thank you. Maybe I'll go this way. Do I have to respond here? Oh, I'll do it here.
Feel free.
Push the button. Thank you, Wendy. It's a great pleasure to be invited here today. Although it's a pity that there's no negotiation with you, like we enjoy for many centuries, not centuries, many decades.
I'm not that old.
And also, I highly appreciate ASBI for organizing this event at this critical juncture where the WTO stands at the crossroad. Now, let me share with you some of my views related to your question. First, I'd like to contextualize the topic in a wider context. The WTO has been perceived as the cornerstone of the multilateral trading system. I hope it's still the case. It's not only because of the rule-setting function, but also its structure with other two pillars, namely the implementation of the agreements by its regular bodies and the dispute settlement system. Regarding this last point, unlike a domestic legal system, international laws quite often lack effective enforcement mechanisms due to the limit to establish the rights and obligations among sovereign states. As we all know, without a means of settling disputes, the rule-based system will be less effective as obligation and agreement could not be enforced. You may recall during the UGA round negotiation, major developed members, including, of course, US and Japan, took the initiative to bring the WIPO-rated IPR agreements in the GATT system for that very reason. For Japan, fortunately or unfortunately, out of 5 cases brought to the panel, she lost 4 cases. However, in Japan, the system is recognized as a leading example of solving disputes with the common language of law. In fact, our former Prime Minister stated this assessment at his address at the United Nations General Assembly. Secondly, I'd like to introduce how the system has been perceived in Geneva during my nearly 5 years term as an ambassador until the end of 2016. Among the 3 pillars, our focus was mainly on the rule-setting function, which has been and is facing fundamental challenges. For the dispute settlement system, the perception among the members was that the system has been a success, and the challenges was how to meet increasing demand because of its success. In this regard, thanks to the efforts of the Director General, Roberto, there seems to be some achievement made within the very severe budgetary constraints. Wendy, I know I'm not invited here to sing yesterday, oh, my trouble seems so far away. I know a variety of issues, Appellate Body matters being discussed by the members. Particular concern seemed to be expressed by the ministers during the informal WTO gathering in Davos last month. So thirdly, how to address the situation. In order for panels and Appellate Body not eventually go beyond the function that they are to fulfill, needless to say, more rapid rule-setting process is looked for. However, I can't be optimistic on that point, given the major divergence of views, including the S&D issue and the nightmare DDA mandate, as we have again witnessed at Buenos Aires. Having said that, during the period of fundamental reflection, not hibernation, I strongly hope some new imaginative and constructive approach will be emerged. As Roberto stated, work in Geneva cannot continue in the same fashion if members hope to break long-standing deadlocks. Now, for the second pillar, which is equally important for the implementation of the agreements, a notification requirement, as already stipulated in the agreement, will have to be more rigidly observed, and more effective follow-up works need to be carried out after the discussion at the regular bodies. Now on the AB, Appellation Body matters, there seems to me two types of issues. Some are of rather philosophical natures and others of technical nature. Therefore, discussion and consultation at both political level as well as at experts level are required. From this viewpoint, it is to be welcomed that some concrete ideas have come up by the experts and that political interests were shown by many ministers. When I talked with the chair of the DSB meeting, Ambassador Ihara, last weekend, I was asked to convey to this meeting that he will continue his informal consultation and he would encourage those delegations who have been working on concrete ideas of a possible solution to continue their endeavors. Sorry, Wendy, I have no mention to go into the detailed negotiation today because I don't like to disturb the very delicate process now underway in Geneva. All relevant issues should continue to be discussed, but the selection processes of Appellation Body should be launched without delay. I like to appeal to all those involved, including Geneva, what I myself and the famous Hollywood movie writer by name of Ambassador Michael Punk used to tell us to the membership of the WTO, that is, let's stop hostage taking. To conclude my remark, as Sir Mick Jagger of the Rolling Stones wrote some time ago, you can't always get what you want. At the same time, Sir Paul McCartney says we can work it out. Thank you.
Well, thank you very much. The Beatles song that comes to me is "Help, I Need Somebody." Perhaps I can turn to Terry Stewart now. You've been around the block on the dispute settlement system. Can you share your perspectives on the underlying problems, both procedural and systemic? And I want to share with you a quote that Ambassador Lighthizer made recently. He said, quote unquote, "Too often members seem to believe they can gain concessions through lawsuits that they could never get at the negotiating table." And perhaps you can comment on that as well.
Yeah, I think that, thank you, Wendy, and it's a pleasure to be here. It's obviously a very important topic. Appreciate the comments that John had to make at the beginning, and he presents, I think, a very cogent overview of certainly how the world looks from the WTO and from many of the members. One of the challenges of a new dispute settlement system has been that there is no check on the dispute settlement body or the appellate body in that context, and that has proven to be a difficulty because appellate body members, like any other judges or all of us, make mistakes. And if mistakes are important in individual cases, there is no way to get that achieved without obtaining consensus, which means that the party who has just won has to agree to lose. And we can all figure out how often that has occurred in the WTO's 23 history, exactly zero times. So an underlying problem is that the system, when it was set up, thought it had a means for clarifications of agreements, but that has never been used. And when mistakes get made, if they are important to a country has no way to get that corrected. And the overreach issue, which is basically what Ambassador Lighthizer was referring to, is one that virtually every country in the WTO has sought to exploit in given situations. This is not speculation. Virtually every country that is a major user has told me that privately in Geneva over the last 2 decades. So countries pursue personal objectives in individual cases which are not good for the system. The reality is you would not have a problem in terms of needing new negotiations or pursuing issues in negotiations if countries didn't believe that they could get through litigation that which they know they should be getting through negotiations. So the negotiation function is in serious trouble in large part because you have a change in the power structure, and the change in the power structure has not yet achieved a consensus among the major players as to relative responsibility. But at the same time, the ability of countries not to raise issues in negotiations that historically they would have taken to negotiations has contributed to the inability to negotiate. So yeah, that is a problem, and is a major problem. It's not just a problem for the United States. John identified an issue where the United States back in the day was more than happy to have the appellate body do something that was not written into the rules and that was outside of the scope. One could say that for virtually every major player. You could identify those situations. That doesn't mean there is an overreach. It means that there's overreach on behalf of lots of people. The second issue that is problematic for the United States and has been for many years, and first of all, on the issue of overreach, this is not a Trump administration issue. This is an issue that goes back almost to the beginning of the WTO. In fact, Congress in 2002 was concerned enough about the problem of overreach that it was built into the Trade Promotion Authority as something that needed to be addressed. And the Bush administration identified an effort to try to deal with that. So that is a fundamental issue because it changes the nature of the bargain. Countries are being subjected to obligations that they never agreed to. And one has to ask, why is that good for the system? Why should countries continue a system that does that to them? And the answer is, for some countries, you get to a breaking point, and my view is that we are at that point, and that is the reason that we will not see a quick resolution. The second issue that has been out there has been the proclivity of the appellate body to take up issues that have not been raised by parties, that are not needed for the ultimate resolution. And so you get a body of work on issues that the parties have not raised, that are not necessary to the resolution of the dispute between the parties, and hence violates the fundamental purpose of dispute settlement in the WTO, which is to find a prompt resolution of a dispute between the parties, not to opine on what the law might be, should be, could be, on issues that nobody has briefed, et cetera. Following that, you have panels and appellate body decisions that use issues that were not actual subject of disputes in later cases and basically refused to budge off of it, even though nobody had litigated the issue. And now it is in a non-precedential system. It is now precedent. All right. So that is a second substantive issue. Those two drive, I would say, the main policy concerns in the United States. The issues that have been raised by this administration have been raised by prior administrations and by many other countries is the fundamental issue of, does the appellate body have the authority through its working procedures or through its actions to disregard limitations that are contained in the DSU? Or is that the responsibility of the DSB to address when the issue comes up? So something like, what do you do if you have a vacancy and there is an former appellate body member who would be available to continue to work on cases that perhaps he or she had started on? The issue is that a function for the DSB to rule on, or is it something that the appellate body can do? So you can find it in lots of areas. The 60, 90-day rule for decisions, right? The DSU says decisions will be made in 60 days. If there's extraordinary circumstances, you can extend it out to 90 days. Decisions routinely go beyond 90 days, and they're done by the appellate body generally without consultation with the parties, and certainly without permission from the DSB, without sanctioning by the DSB on it. So those are the three main areas of concern, kind of an overarching one of who's got the responsibility. Is it appointed individuals, or is it sovereign nations acting through the DSB who have the ultimate responsibility to interpret the DSU? And then you have the two that have kind of gotten off the tracks, that in large part are off the tracks because you don't have the ability to control the appellate body in a meaningful way, simply because the consensus system creates those challenges. So I would say those are a few of the problems that we have.
Okay, we're going to follow up on that, but first let me now turn to Paul Bluestein. Paul, and I think it kind of gets at Jake Schlesinger's question. There's just a lot of people are just very focused right now on China and the WTO and whether the WTO rules really address a lot of the practices now we're seeing in China. John had mentioned that both the U.S. and China have sued each other. I think you said that the U.S. has taken 10 cases against China. China's taken 8 cases against the U.S. Paul, in your article, which is available outside, you look into, in quite some detail, 2 WTO dispute settlement cases, one where China won, one where China lost. And I think you made some important conclusions. So perhaps you can share with us your perspectives on these issues.
Yeah, thanks very much, Wendy, also for inviting me to participate in this. And I do try to shed light on the question of dispute settlement, particularly as whether it really works with regard to China. As you say, it's a paper that is about one case that China won, one that China lost, and I'm sure that, with Valentine's Day being just around the corner, that for that special someone in your life, this paper it is out there somewhere. Well, so I try to explain in the paper that I'm not looking at one China win and one China loss just because you win some and you lose some at the WTO. That's a fairly sort of standard point that people make. It's rather obvious. But it's rather, I try to show by delving in really in a granular way in these cases how the system works and doesn't work, especially with regard to China, and try to illuminate this debate that we're talking about here. And at the risk of just repeating what a couple of people have said, let me just sort of frame that debate. That on the one hand, you have defenders of the WTO saying that, well, if America has a problem with China, bring a WTO complaint. This is how you resolve disputes. The whole idea of the system, right, is countries can take their complaints to an impartial tribunal rather than engaging in tit-for-tat trade wars. If we get into a tit-for-tat trade war with the 2 biggest economies in the world, it's going to be quite costly for both of them. There's a lot of argument about which one is going to be more costly for. There's certainly going to be a lot of collateral damage for some other countries as well. So if we undermine this system that we have for resolving disputes, that's a more likely outcome. And now on the other hand, you have, on the other side of this debate, you have critics of the WTO, most notably Bob Lighthizer, saying, look, don't be naive. This gets to Jake's point that the rules were never designed to cover an economy that has evolved in the way China's has, with all this industrial policy, techno-nationalism, state capitalism, China Inc., all these terms that have been bandied around. I think a lot of they're quite apt. It's a real phenomenon that the Chinese party state acts in all kinds of ways that help Chinese companies compete against foreign companies, and often in unfair ways. And furthermore, the critics make the point that Terry just made, that there's too much overreach by the appellate body. Now, I'm a journalist. I'm not a legal scholar. And one other plea for you, aside from Valentine's Day, for you to take a look at this paper is I am in the process of writing a book. This paper will be part of it. And if you read the paper and you see something really dumb that I've said, or even that just needs modification, please let me know. But the paper tries to go into these 2 cases and write about these cases in a journalistic way. Real people, real companies, real lawyers, real judges. I think that the sort of the human interest side of this, as well as the legal issues, help illuminate this debate that we're talking about today. So let me begin with the case. I'm just going to go through these as quickly as I can. The case that China won. Now, to the trade wonks in the audience, this is DS 379. Trade wonks always, they know immediately what DS 379 is. This is a landmark case. It revolved around a crucial question. Where in China does the private sector end and China Inc. begin? Now, this story begins in 2007. It begins with Terry's firm, Stewart and Stewart. And what I'm going to say some very flattering things about Terry's firm, and I'm not trying to get a commission, Terry, for any client work you get out of this. But Terry's firm represented some American companies in heavy industry that were making industrial products. One that I focus on in the paper is off-the-road tires. These are the kind that are used in tractors, construction equipment, things like that. Not for autos. And these companies, these American companies, were absolutely being killed by Chinese imports. And they argued, well, that the imports are subsidized. They wanted trade remedies. They wanted duties imposed on them because they're unfairly subsidized. So if you go to the Department of Commerce Central Records Unit over at 14th and Constitution, as I did, and you go, and there's thousands and thousands of pages that Terry's firm filed there in this case. They make a really interesting argument that China was, in fact, subsidizing these products, particularly the tires. Doing so partly with loans from state-owned banks to tire producers, and also there were allegations, that these companies got cheap land, cheap electricity. But there's some amazing legal detective work in these papers, thousands of pages, showing how state-owned enterprise, Chinese state-owned enterprises were helping to subsidize Chinese exports by giving cheap inputs. Now, in the case of the tire company, the obvious input to give would be subsidized rubber. And again, these documents show that Sinopec, the China Petroleum and Chemical Corporation, does this ring any bells, Terry? Biggest petrochemical company in China, supplied a component of synthetic rubber, and that enabled Chinese tires to be exported more cheaply to the U.S. market than they would be otherwise. So there were big investigations and hearings at the Commerce Department, the International Trade Commission, as there always are in these cases, and the U.S. government imposed duties on Chinese tires and some other products that were deemed to be unfairly subsidized for the similar reasons. China said, "Wait a minute, this is not right. You can't. You're violating the WTO rules," and they sued the U.S. and brought a case which went before a 3-judge panel in July 2009. China's argument was, okay, we have these state-owned enterprises, but they're real businesses. They're expected to earn profits. I mean, they have stockholders. I mean, okay, the Chinese government owns a majority share in them, but they don't give subsidies. That's not what they're there for. And under the WTO rules, you can the only things that can give subsidies are, 1, governments, and 2, something called public bodies. And they were arguing just because these companies are majority owned by the Chinese state, that doesn't mean that they're public bodies. You have to prove that they're vested with government function or authority and entrusted and directed to provide a subsidy. So the U.S. was the defendant in this case, and the U.S. said, "Are you kidding? Don't let China Inc. get away with this." This was the U.S. argument. Of course, these state-owned enterprises are involved in subsidizing exports. The Chinese government is a majority owner. They may not interfere every day in the workings of the company, but they do have the power to appoint boards of directors. So this clearly, this is a case of China Inc. at work. It's not transparent. You can't. There's no public order that comes from the Chinese government to these state-owned enterprises, but we know what's going on. And when this case came before a 3-judge panel in Geneva, the panel said, yes, the U.S. is right. There must be subsidization going on here. But then China appealed to the appellate body, and the appellate body reversed and said, no, we agree with China. State-owned enterprises aren't necessarily public bodies just because they're majority owned by the Chinese government. And subsidization isn't as extensive as the U.S. has claimed, and the duties that have been imposed are illegal, and the U.S. has to get rid of them. Well, you look at that story, and you say to yourself, holy cow, Bob Lighthizer right. The WTO is pretty useless when it comes to dealing with China Inc. We know in our gut that these Chinese exports must be subsidized, and just because we can't offer hard proof that subsidization is going on, that doesn't mean it isn't happening, and we have no way of protecting ourselves. That's not fair. And this is obviously very troubling with regard to the other mercantilistic practices that China engages in that involve non-transparent manipulation of markets, particularly the strong arming of companies for technology transfer. Okay, so that's one side of the argument. The other side is China has lost quite a number of WTO cases, including some bought by the US. So that's the other case that I look at, the one China lost. And this one I'll deal with much more briefly than the other one. This is, for you trade wonks out there, this is DS 431. This is the rare earths case. This is about China's effort to limit exports of rare earth. These are minerals that are used in high-tech products like cell phones and electric car batteries. And China said, the reason we're limiting these exports is because it's incredibly environmentally destructive to mine them, and we're trying to clean up our environment. And the U.S. and Japan and the European Union brought a case against China. Said, we know what you're doing. You're not. This is not really about the environment. What you're doing. This is industrial policy. This is classic China Inc. You're discriminating against Chinese in favor of Chinese domestic companies at the expense of foreign companies. It's discriminatory. That violates WTO rules. So I'm not going to go into all the legal twists and turns, but I want to highlight one very superficial aspect of this case that might seem minor. I think it's quite revelatory. So at the very first hearing of this case, this is in late February of 2013, just to set the time frame. In a great big hearing room in Geneva at WTO headquarters, there were about 100 people gathered for this as this case began. And there were 3 panelists, and there were members of the Secretariat, and there were lawyers for the complaining for the U.S. and the EU and Japan. And then, but there was a very big delegation from Japan, 35 out of 100 people from China. I was told, the Chinese always do this. They always have the biggest delegations at any hearing at which they're a party. Some people who were telling me about this said, it's really off-putting because there's all these Chinese, these big delegations, and they often, you see them with bags from the fanciest boutiques in Geneva, and, so why are they really there? Well, as I looked into this, it turns out there's a very good reason for it, quite noble, really. It shows that officials, the reason to bring all these people to Geneva is to show officials from the affected ministries and some of the state-owned enterprises even, how fairly and thoroughly the Chinese argument is being heard in Geneva. Ministry of Commerce people try to make sure that the stakeholders come. And one really interesting story I heard in this regard was that there were a bunch of Chinese in attendance at a hearing, and a judge on the appellate body, who was an American, asked some really, really tough questions of the U.S. side. And that really impressed the Chinese attendees because, a U.S. judge asking really tough questions of her own country's attorneys. And, whether this is the reason or not, the fact is China has a really good record of compliance with decisions that go against it. People in the Chinese government do seem to take to heart the notion that this is a impartial, fair system, and when they rule against us, we ought to comply. Now, China isn't perfect about complying. I don't think there's any country that's perfect, but I would have to say China is a darn sight better than the United States in complying. And this rare earths case turned out to be a perfect example because there were some things about this ruling that really angered the Chinese. I won't go into I'm happy to do it in the Q&A, but anyway, there were some aspects of it that really infuriated them, but they did comply. And they did, and when the appellate body came down and issued its final ruling saying you have to get rid of these export restrictions, they did comply. So, okay, so as I said, one case China wins, one case China loses. What conclusions, what big kind of takeaways can you get from this? You heard Wendy talk about the strain of argument that, okay, the dispute settlement system isn't perfect, but it serves us well. That's kind of where I think we ought to, looking at these two cases. The question is, what should be done about these imperfections? Is it right for the U.S. government to be pressuring the appellate body to change its ways by blocking reappointment of judges it doesn't like, as it's done in the past, or as it's doing currently, holding up the appointment of new judges, as it's been doing in recent months? I think we're running a big risk here of making the perfect the enemy of the good. We're throwing out the baby in the bathwater. there's all these cliches that people throw around in this debate, but I think they're apt because for all its flaws, this system does constrain Chinese policy within certain bounds. Not entirely, but again, recall the point I was making about the rare earths case. The Chinese send large delegations to Geneva just to see, to be shown really that the system is reasonably impartial and that they can get a fair hearing. If we browbeat the WTO dispute settlement system, as this administration seems rather inclined to do, we're going to risk destroying the WTO's value. If member countries lose faith that they're going to get fair hearings in Geneva, it's only going to be a matter of time before they start resorting to tit-for-tat. So are we going to risk that outcome in an effort to force China to change or abandon or drastically alter its economic system, its economic model? I think that's a very highly unlikely outcome, that we're going to be able to force them to do that. Are we going to have faith in our own American system, market-driven, transparent, entrepreneurial, which has produced technology giants that are the envy of the world? I'm not trying to argue that all problematic Chinese policies ought to just be accepted and that we ought to sort of roll over and take it. But if the choice is between that and taking actions that really blow up the system and that risk undermining the credibility of this dispute settlement system, I would say it's a very difficult, tough choice, and we ought to be very careful. Sorry, okay, I'm being told I'm way over time. So anyway, that's my final point.
Thanks, Paul. Steve, last but not least, but I'm going to ask you to be pretty quick in your response, and then we'll just turn it the questions to the audience. Can you share your perspective once again? Just to remind everyone, you are a USTR lawyer, now you're in a law firm pursuing dispute settlement cases on behalf of clients. Do you think the system, as Terry said, is kind of at a breaking point, or do you side more with Paul that there's a lot of good to this system, and we should work, we should not let the perfect be the enemy of the good?
Yeah, so as a good lawyer, I'm going to say it depends. But
okay,
it really
thanks. Okay.
Questions. Yeah, it's not broken. I mean, it works. Does it work well? I think it can be improved. Sometimes it works, and sometimes it doesn't work as well. The WTO agreements, in my view, are not. They're not about trade liberalization at all costs. It does recognize the sovereignty of its participants. It builds in legitimate protectionism for these sovereigns and legal exceptions. The agreements on their face as a whole, in my view, is rather balanced. And it's the role that the WTO panel and the appellate body really to maintain that balance. But when you put the authority of interpreting and clarifying in the hands of individuals acting on their own personal capacity, that balance can get skewed, and I think that's what's sort of happened here in the last couple of years. Individuals, when put in that position of power, and it's heady stuff. You're deciding big issues involving sovereign nations. They want to fix things. They want to respond to every inquiry. They want to do what they think is right, or what they think is the right answer. But that's not their job. Their very limited role really is to interpret and clarify a limited set of agreements that was not built to answer every trade question from here to eternity. They're tasked to explain what they think the sovereigns want, not what they think they want. So now you have reports that basically contain dicta. You have reports that are filled with gaps. I know nobody ever says they do it, but what you see is what you get. They create new rules. They create new tests. They cite for authority, not to the agreement sometimes, but to their own reports in the past. I mean, all this stuff, this really needs to be fixed, in my view. But, that doesn't mean it's broken. I think that the system gets it right the majority of the time. And every once in a while, they'll go off the rails. And they'll decide to take things into their own hands. And there should be ways to be able to restrict the latter, establish some accountability without getting rid of the whole system, really, unless that's your intent. But assuming that's not the intent, change can start, in my view, with the Secretariat. Panels in the appellate body really needs to be reminded constantly of their limited roles. that there clearly is some confidence lost in the system, and they need to work to rebuild that trust and that confidence. There needs to be more communication with the members. When you work with them, be open to perhaps some suggested small procedural changes. We can talk about that later. Be comfortable, really, to be able to say that you don't know the answer, or there is no answer, because the agreements don't have an answer. It's just the growing pains of, if you remember, this really is a young system. This is 25 years. This is not, this has not been around hundreds of years or so. This is just a system sort of getting its sea legs, in my view. But I will say this, I will say that despite all this, for the appellate body and the Secretariat, I would say not to stop, that you need to not stop doing your job. You need to resolve the disputes as best as you can. You need to uphold the rule of law, regardless of whether the losing side is going to complain or threaten. I think it's just right now, as I said, this is just, we're in the middle of an up and down, the growing pains of an organization.
Thank you. Oh. All right, let me turn the questions now to the audience once again. Can you just introduce yourself and limit yourself to one question? Let's take a few, and then we'll split them among the panel. No questions? Yeah, in the back. Oh, Elizabeth.
Oh, sorry. Please. Thank you, Wendy. I'm Elizabeth Bose. I'm head of trade branch at the Embassy of Australia and previously posted in Geneva as disputes counsellor. Thank you very much for all the remarks this morning, particularly from John Dank and from the panel. I'm wondering, when we talk about overreach and the accusation or allegation that the appellate body tends to resolve issues that haven't been presented to it, or to really extend over to dicta, whether one of the problems lies with the actual experience of the appellate body members themselves. When it was first set up, one of the early members was Justice John Lockhart, didn't have WTO experience, but he was a federal court judge in Australia and had extensive judicial experience, including with case management. And I'm wondering if perhaps one or two appellate body members that did have some sort of judicial background, very experienced in adjudicating cases, which does mean just resolving the issues before them, might help in at least addressing some of these actions that or allegations that have been thrown at the appellate body.
Other questions? Okay, well, why don't we start with that?
Doug Palmer.
Yeah. Oh. So I guess it's just a question for Terry. I mean, when we talk about overreach, these decisions where we see the overreach, is it mainly in the area of trade remedy laws from the U.S. perspective? Are there other examples outside that area where people feel like the appellate body or whatever the original dispute settlement body went too far? Or is the concern mainly that the WTO is nicking away at the U.S. ability to oppose anti-dumping and countervailing duties?
One more. Jake?
So one of the implications of John Adank's comments was that the U.S. has not come forth with specific proposals on what it wants. So I'm curious if some or all of you could fill that gap and articulate, if you were being constructive in trying to not just criticize the appellate body, but propose something that is a feasible plan of reform, what would it be?
Okay, why don't we take those, and with respect to Jake's question, why don't we start with that, because I think that's really an important question. I think we all have a good grasp of what the deficiencies are, but what I would ask each panel member, really limit yourself to up to three key changes you would recommend that should be explored in Geneva as a means to fixing not only the procedural deficiencies, but also some of the systemic ones too. And who wants to start? Terry.
I have the advantage that I put it down on writing, so you can see it in the paper that's outside if you haven't picked up a copy. I think that the challenge to address these is a consensus to modify 3.2 and 19.2 to clarify what it means not to create new rights and obligations. I think that John is correct that the likelihood of that happening in my lifetime is not high. But that is, I think, part of where the challenge will be. I think in terms of the other fundamental issue of whether or not the appellate body has the right to deviate from limitations in the DSU through working procedures or otherwise, is something that could similarly be pretty easily addressed either by the appellate body itself deciding to take a step back and to start to run things through the DSB, or by the membership coming up with a clarification of what the obligations of the appellate body are in that manner.
Just on the issue of the the appellate body fulfillment and how to fix that. I mean, to me, Rule 15 is just indicative of the problem. It really isn't the problem, right? It's this notion that the appellate body and other apparatuses in the WTO have kind of gone off and done their own thing without engaging with or discussing with the members, and they want to maintain this member-driven nature of the organization. And I mean, so some of this, as I said before, requires some confidence-building exercises. And negotiators, good negotiators like Wendy, they have these ideas, and it's just thinking about what you can possibly do to sort of build that confidence. How to sort of ensure that there's no feeling or there's more accountability to the apparatus of the WTO. There's some ideas that have been floating around out there for years. There's things like you've got the interim report reviews at the panel level. Why not the interim report reviews at the appellate body, for example? I mean, that kind of stuff seems to me is almost like a giveaway. Why? The way that it works in the panel is when you have an interim review, people look at it and there's not a whole lot of changes to it, but it does help countries prepare for it, sort of point out some of the issues that frankly could make the report better. Other is a little bit more, I guess, that is a little bit more problematic for some people is there's this notion of partial adoption of reports when it gets to the DSB. The partial adoption idea, though, is premised on actually a positive consensus. I mean, this notion that, as Terry said, no one's ever going to say that they're going to, one side will never say they're going to lose. But if you had a system where basically if both sides say, look, they overreached here, probably never get used. We're very minor. But why not agree to a system like that that says to the membership, look, we're gonna abide by what you guys say at the end of the day. It's not going to be what we say or the highway. It's our way or the highway. But there will be a collaboration in ensuring that the system is confident moving forward. And then just things like resources, providing more resources. I mean, there is concern about the 60, 90-day rule. There's concerns about things like that. There's concerns about hiding the ball. Members basically, have one measure that's in problem and halfway through a dispute they change, or they structure things in a way to game the system so that measures constantly change every year. I get that. But I think having resources so that the WTO and the system can move more quickly to get at those issues, to be able to agree to some expedited process when you look at a measure that's very similar to another measure. I think those are changes. I don't think they're hard. I don't think they require, you getting the ministerial together, which is really hard right now. But to have some of these things. But in the past, I mean, the Secretary has been adamantly against any of this, which is only makes the members think, well, gee, they don't want to do anything different. They want the control in their hands. They want to be in this low black box.
Jane, did you want to comment?
Yes, I have 3 points. First, as Wendy, you have mentioned, the 3 pillars of the WTO, they are interlinked in a way or another. Well, today we are focusing our discussion on this dispute settlement, but I would like to underline the very importance of the work now being undertaken by the regular bodies to monitor whether members are taking the measure consistent with their obligation. But it's working, but it will have to be improved much more. For example, there are requirements for the members to report the measure they have taken for the sake of transparency, so forth. But quite often, it's not being carried out. So we have to encourage all members to fulfill their obligation under the agreement for their notification agreements. That's the first point. And second, what we can do, relating to this point, is to try to strengthen their peer review exercises now being undertaken at the WTO. There's a system, there's by name of trade policy review, but I'm not sure whether it really works. For Japan, as well as for US and China, we receive more than 100 questions. We'll respond to these questions. Well, people are working very hard. But after the discussion, we'll forget about what we have discussed. And all our questions and answers were in our files somewhere else. But we'll continue our trade policy as if nothing happened. So how to strengthen this system? I think there are a lot that we can do. Really, for example, well, I'm retired from the foreign ministry, so I can say it. I like blame and shame approach, which is not usual for diplomats to say.
Particularly from Japan.
Particularly from Japan. But, for example, at the peer review process at the OECD, quite often we blame each other. We are accustomed to do that. So why not at the WTO? Let's blame each other in order to shame them. That's what I wanted to do. And secondly, I fully agree the importance of having enough sufficient resources at the Secretariat. So I really appreciate various initiatives being undertaken or being considered by Roberto and John yourself. Thank you.
Okay, maybe we can then turn to Doug Palmer's question to Terry. Did you want to comment on that? Is when you talk about overreach, are you mainly concerned about trade remedy cases?
Since half the cases involve trade remedies, Doug, you would not be surprised that there's a lot of overreach in trade remedy cases. But if you look at the paper, we've identified a whole host of comments by various governments in individual cases, and you'll find that they go far beyond trade remedies.
If I can, the other part of, to Terry's point, the recent decisions on the TBT agreement and the determinations on Article 2.1, 2.2, and the conflation of those two, that's, people are still trying to work that out as new disputes come on. Nobody can make heads or tails out of what the appellate body just said about 2.1 and 2.2.
I just want to come back to the issue of what can be done to improve dispute settlement system. And this is a bit of a grenade I'm going to throw here. Someone said, I don't remember which one of us said, that one of the problems with dispute settlement is that the appellate body doesn't seem to be willing to admit mistakes and reverse itself and because all courts do make mistakes, and I think people on the appellate body are quite frank in admitting that they do too. This is something I get into in the paper. I didn't bring it up it wasn't particularly relevant to the question of exactly about China. But the appellate body secretariat director is a man named Vernors. He's an Austrian. And he is an unbelievably dedicated civil servant. I want to emphasize this. He is completely apolitical. He is not anti-American, but he is objected to quite strenuously by a number of Americans I've talked to, and even people from other countries. The reason is that he's incredibly powerful, incredibly hardworking, and his whole agenda is to protect the appellate body from ever admitting that it made a mistake. That seems to be what he regards as his life's mission. He's a great guy. He's completely honorable. And he really should be held in high esteem for dedicating himself to protecting this institution. But people who love him and people who hate him, and there are quite a number of people on both sides in Geneva, will say that he is a big problem because he's so powerful. He has enormous influence over a number of the appellate body members, and he keeps that. One of his objectives is to ensure that there's absolute consistency from one opinion to the next. Well, that leads to decisions where they won't admit mistakes in the past, and this is a big problem. And I'm not, one obvious solution to this is this guy's been in his job a long time. Maybe they ought to find something else for him to do. But another way is for the appellate body or the dispute settlement body or whoever to issue some kind of pronouncement saying, look, there is nothing in the WTO rules that says that the appellate body has to follow precedent. There isn't. And we want more admissions of mistake. I don't know how exactly you phrase that, but that's something that I think would help deal with this problem. Because once the system has made a mistake, then if it has to keep repeating it, it obviously gets worse. It's exacerbated.
Ron, good to see you.
Ron Lorenzen, formerly of U.S. Department of Commerce and USTR. I guess the question that I had has to do with the so-called filling of gaps. And Wendy and Ambassador Oteba mentioned the 3 pillars. Anyone who's participated in a trade negotiation, or maybe any negotiation, will experience the phenomenon of, because of negotiating positions, you can sometimes, the best you can reach is constructive ambiguity on certain controversial issues. I don't personally see those as always being gaps, but they can be perceived as gaps by some. And I guess from my point of view, the important work that the ambassador mentioned in terms of monitoring and peer review in committees and standing bodies can be added to by interpretive work that those committees can undertake. It's not ultimately binding guidance, but it can be important work for how you deal with different approaches to those constructive ambiguities. And to me, that's a much more sort of WTO consistent way of resolving so-called unfilled gaps, rather than kind of gambling in the dispute settlement system. So is that an area that deserves more attention in terms of what we used to call the built-in agenda of the WTO, the implementation work?
The BIA. I'm
Yes.
going to call Claude and then Jeff, and then we'll turn to the panel.
Claude Barfield, AEI. Really 2 points. One, to what degree, and this is the lesser, could the problem be solved if the appellate body, now I don't know how this would be done through the decision making, but when I wrote about this years ago, the lawyers kept telling me the panels in the appellate body are obligated to answer every question before them. And there is this kind of throwaway phrase about clarifying. On the other hand, as we get farther from the negotiations, there are, as others have said, there are going to be lots of gaps, lots of places where the negotiations have not filled things in. What about introducing something like non-liquet or some political issue that the panels of the appellate body can throw it back to the negotiators? We have no instructions on this. That's one thing. And the second, more dramatically, is we dance around the imbalances, but is there some way you could then, once a panel or the appellate body in the end has made a decision, that you could get the dispute settlement body in an easier way? Say if a third or 40% of the appellate body of the DSB disagrees, there'd be some way to block. In other words, everything we've talked about here and has been talked about in the last couple of decades is protecting the appellate body and the DSU. I'm in favor of that. But the imbalance is so great now. Would it not have better legitimacy, democratic legitimacy at the international level, if somehow you could review decisions?
Jeff?
Jeff Schott with the Peterson Institute. Let me just try to distill what was in the last 2 questions. The purpose in the WTO at the start was to be a forum for continuing negotiations. And under that system, you don't have a problem of judicial overreach because you have continuing elaboration of the rules. That has failed. And so how do you build an incentive to at least have narrowly focused attention to the gaps or ambiguities in rulemaking? There has to be a rule. You can't talk about, well, we're going to fix the trade remedies because that's not going to happen in a big negotiation. But you can have, and I think Claude was suggesting, a legislative remand where if the appellate body had the authority to say, you've brought us a dispute, but the dispute just basically cannot be resolved under the current rules. And if you want to resolve it, you're going to have to go back to the committee of jurisdiction or a broader area to focus on this specific aspect. Otherwise, neither side gets any satisfaction. Is that practical in any reasonable period of time before the system collapses? And I'm very unhappy with the panel or members of the panel and the speaker who suggested that the status quo is sustainable, because I think most people would look just very shortly down the road and say the status quo is not sustainable.
Okay, so we have 3 questions, Ron, Claude, and Jeff. I think a lot of them are getting to the issue of filling the gaps and how to deal with the fact that the rules of the WTO just haven't been updated in many years, and so you have panels who, in the appellate body, looking at language that frankly is dated and needs clarification, and in some cases there just isn't clear guidance. So who wants to take on that issue? Terry.
Well, let me answer the very last question first. In my view, there's nothing that prevents the appellate body from doing that now. It has been their approach that they have to resolve every dispute, and that was never the approach in the GATT, and there's no reason it has to be the approach here. In terms of Ron's point, it's an excellent one. Historically, the committees were much more active in terms of exploring differences in systems, questions that came up, and what might be agreed within the committee process, et cetera, for modifications that could be made in terms of improving performance. Part of the problem in the last decade has been, last decade and a half, I guess, has been that the committee process has been a lot less focused on, in part because you had long-running negotiations, and that was sucking up a lot of the oxygen in Geneva in terms of being able to do it. But even today, where there's more attention paid on the committee process, you have far fewer people from capital. If you're really going to do the kind of process that Ron talked about, you need much more active engagement and commitment from the capitals to make that happen. But can that deal with some of the issues and get greater coherence? Sure. Does it deal with the problem of overreach? My guess is no. Absent some change that provides guidance to the appellate body and the panels as to what 3.2 and 19.2 mean.
Yeah, just on the issue of legislative remand, I mean, I think it's an interesting concept, and it's one where it could work because, I mean, people look at, and this discussion here is talking about the dispute settlement system like it's a court, but it's not. I mean, it is set up. If you look at my view, at least, is the WTO agreements really is just a set of contracts, and then what you have is the arbitration clause that's supposed to resolve issues while you allow the relationship among the parties or among the members to continue. And so there is that sort of mechanism, and this notion of it going to trade war. I mean, that's the whole thing. And somebody mentioned that this is all was trying to avoid. So when you get to a point where you're like, well, look, the contract doesn't say anything about this, and we want to have the people who wrote the contract to go ahead and tell us, to fix it. I think that is workable. It takes confidence, it takes maturity to get there. Hopefully, we'll get there at some point. I think with the appellate body itself right now, getting that sort of background and having comfortable in doing that, I think that's pretty important. And it's a question of chicken and egg too, in my view. Some people say, well, it's because the legislative aspect but the system isn't working, and that's why you got to legislate through a dispute mechanism. But I think of it as the other way around. I mean, if you legislate too much through a dispute mechanism, you're really not leaving much room for the legislative aspect to work. If you can at least say, look, we're missing some holes here, that itself could lead to the other side, picking up steam again. And the blocking by the DSB, I think that's a little hard because, these disputes are intended to be between the parties only. They're not intended to be among third parties or anybody else who can come in and weigh in. But again, if there's a way of partial adoption by the parties who are there, and if both sides, the complainants and the respondents said, look, we can't agree whether you should block, decisions, findings 1 through 5, but decision 6, that was just way out of left field. We both think that shouldn't be there. I think that's perfectly legitimate.
On the second question of whether or not the regular bodies can start the interpretative work, it sounds interesting, but if we are to start that kind of exercises, we need a consensus again. And I'm sure that we will be blocked by someone, not in the United States, but maybe the developing members. For example, developing members, they want to clarify the S&D rules and regulation embodied in the agreements. And we've been discussing this for decades again, but nothing happened. I think the better way to address is to hold a kind of informal seminar or symposium. Brazil did it for the trade and exchange rate to further understanding of what do we have as an agreement and what we don't have. And some time ago, US held a meeting to discuss and study about the safeguard mechanism. I think it's a good trial.
Well, thank you. And with that, I'm going to conclude this morning's event. Again, thank you very much for coming. Thank you to our panelists. Thank you to our keynote speaker. And please join me in a round of applause for the group.